If it pleases the court, I'm Rebecca Odell Townsend. I represent the plaintiff, Bridgeport South. We'd like to reserve 5 minutes for rebuttal. As you may recall, this is a case that went out on summary judgment. Plaintiff's counts for breach of contract, quantum merit, and fraud. The standard for summary judgment, as you all know, is that all the facts, all the evidence, all the inferences are supposed to be taken in light of the plaintiff, Bridgeport South, and then even if there's the slightest doubt that there's a material issue, it precludes summary judgment. We believe in this case there are genuine issues of material fact in every single one of these counts. For instance, in the breach of contract, CVS argues that we were not the procuring cause. Well, there are genuine issues of material fact as to what the oral contract was. In our complaint, we allege that we were promised, Bridgeport was promised, if they researched and located and worked these intersections, that they would be paid when there was a closing on this intersection. CVS, in their answer, admits that there was an oral contract, but says that we had to be the procuring cause, which is kind of nonsensical because procuring cause is really if there isn't a contract. But anyway, according to CVS, under the oral contract, Bridgeport had to be the procuring cause in order to be paid on this intersection or for this particular site. So there are genuine issues of material fact as to procuring cause. CVS says that we had no contact with the sellers, but the evidence is to the contrary. We had evidence with the sellers, we had communications with the sellers, we have in the depositions that they communicated with Tim Lowe of Motiva for this particular site, and also there's even a letter in evidence that we contacted Pauline Rofi on behalf of CVS, again, to purchase this for CVS. CVS says that Felix Fudge testified that he was working on this exact site with these exact sellers when Richard Liberto, who was Clay Wilson's buddy, another broker, threatened to kill him. He was working on with these exact sellers. He testified that he was working with these exact sellers when he received the 12/14/1999 letter intentionally excluding him for further negotiations with these sellers. So there's genuine issues of material fact. There's genuine issues of material fact just as to that December 14th letter. Rob Warren, who was CVS's attorney, testified that that letter was not intended to include those sites where there was contact with the sellers, which in this case there was. He also agreed and admitted in his deposition that that would have been intentional exclusion if that's what that letter was intended to do. There are genuine issues of material fact regarding the statute of frauds. There are genuine issues as to whether Bridgeport fully performed or partially performed under this contract. CVS admits in their answer that Bridgeport performed services for CVS to find locations. That is at least partial performance. Both full performance and partial performance take this case out of the statute of frauds. There's, unless, under partial performance, unless they are this is a personal service contract. Bridgeport alleges it's not a personal service contract because other brokers were brought in and commissions were split in order to speed up this process for CVS. In other words, it was delegable there, and it was delegated even in this case. Therefore, it's not a personal service contract. So whether it's full performance or partial performance, it's outside the statute of frauds. It's also a genuine issue of material fact as to what was the term of this contract. Bridgeport asserts that it was indefinite, and CVS even admits in their answer brief and many times in the motion for summary judgment that this was a term for an indefinite period of time. Contracts for an indefinite period of time are also outside the statute of frauds. Both Britt Goodson and Felix Fudge, the realtors in this case, the real estate brokers for Bridgeport in this case, both testified that because at the formation of this contract the circumstances were so uncertain The contract was necessarily for an uncertain, indefinite period of time, and we go into great detail in our bridges why it was an uncertain, in our briefs, as to why it was uncertain. They didn't know if CVS was even going to come in the market. They didn't know if CVS was going to acquire Eckerd Drugs. They didn't know if they were going to open one store or 100 stores. It was for an indefinite period of time. There are genuine issues of material fact regarding the statute of limitations for the quantum merit. The biggest genuine issue of material fact is that we do not know, there is nothing in the record that tells how long Bridgeport worked and provided services for CVS. CVS argues that those services ended with the 12/14/99 letter. That is not true. The record shows that Bridgeport continued to work for CVS, with CVS, on sites for, we think, years. It's not in this record, it's outside the record. That's a genuine issue of material fact in and of itself. The other thing is that both sides agree that Bridgeport was only going to be paid if there was a closing. In this particular case, they worked this intersection for at least 6 months. The documentary evidence shows that they were working on this intersection, one site and then the other, for 6 months. But they still would have not paid, everybody agrees they would have not been paid for this intersection and that work unless there was a closing. That means that this case is like a contingency case. And the Florida Supreme Court in Rosenberg versus Levin said that in contingency cases, a cause of action for quantum merit in contingency cases arises only upon the successful occurrence of the contingency. In this case, the contingency was the closing. So in this case, the statute of limitations did not run until there was a closing. And in this case, we filed within 4 years of the closing on this particular site that we are saying we are owed commissions, both as quantum merit under an oral contract and as the procuring cause. And finally, under fraud. CVS has alleged that we failed to state a cause of action for fraud. And CVS argued to the trial court that this was a case for fraudulent inducement, that they sent a letter terminating our services before we had any contact with the sellers, which we know is not true. So first of all, that's it's something that should have precluded summary judgment. But in this case, Bridgeport did not allege fraudulent inducement. They alleged a continuing fraud. In their complaint, they say that they were repeatedly assured repeated representations, and the evidence has showed that. Joe Kasich, the vice president of CVS, not only promised at the beginning in order to induce this oral contract with Bridgeport, but continually and repeatedly repeated these promises that they would be paid for their services when there was a closing. He repeated that when the developers changed. Rob Warren, CVS's attorney, repeated that after the 12/14/99 letter. Felix Fudge called CVS's attorney and said, "What is this?" And he said, don't worry, you'll be paid. Not only will you paid for this work on these sites you've been working, but you're also, by the way, the procuring cause. Joe Kasich told Felix Fudge and Britt Goodson that there was going to be a written contract drafted that would memorialize this oral contract. And he repeated it many times to Britt Goodson and to Felix Fudge. And as we know, Kathy Goodson, who was CVS's real estate director locally, also asked for that contract. They repeatedly said, don't worry, it's forthcoming. Our attorneys are just too busy. Bridgeport found out in the deposition of Rob Warren on January 31st, 2012, that Rob Warren had been instructed by CVS not to draft the written contract, that CVS was not going to sign it. That's fraud right there that was repeatedly given to Bridgeport so that they would rely, so that they would keep working. Last thing I want to mention is that CVS many times in their Rob Warren's affidavit, in their briefs, in their motion for summary judgment, say that commissions were paid to retail sites That is who did the negotiating. That is who was the procuring cause. Retail Sites was not a licensed real estate company. It was illegal for them to be paid commissions in this case, and so those contracts that are attached to Rob Warren's affidavit are actually illegal contracts. There should have been no commission paid to Realty Sites, even if you would agree for some reason that Bridgeport wasn't entitled. We would ask, therefore, because of all these genuine issues of material fact, because fraud is by its nature something that a jury of fact and that a jury is supposed to determine, reliance on these representations is also a jury question. We ask that this court would please reverse this summary judgment and remand this case for a jury trial. Thank you.
Thank you, Ms. Gilman.
Thank you, Your Honors. May it please the court. There is no genuine issue of material fact as to when the December 1999 letter and the January 2000 letter were received. We recognize the standard for summary judgment. We are not arguing that there aren't issues of fact in the record. However, in construing all of the facts in the light most favorable to Bridgeport, this case, the summary judgment was properly granted by the lower court. Specifically, a genuine issue has to be a reasonable issue. It can't be a false or colorable issue that's cited at Byrd versus Leach. And in Landers versus Milton, the Supreme Court indicated that it is not enough for the opposing party merely to assert that an issue does exist. The party seeking to escape the statute of limitations must bear the burden of proving circumstances that would toll the statute. The evidence must be competent to generate a material issue of fact. The focus is on the genuineness of the issues of fact that are created here. It cannot be irrelevant, speculative, inadmissible hearsay. The Florida Supreme Court and the Second District have both held that a summary judgment cannot be based on inadmissible testimony. And that is what opposing counsel attempts to bring up. The most important issue is, as I mentioned, the December 1999 and the January 2000 letter. What is the contract that the plaintiff is sued upon? Specifically, if we look to the contract in the pleadings, the plaintiff has sued on an oral agreement to be an exclusive broker for CBS, that it would be paid $100,000 in real estate commissions, and specifically for this site, which is located at East Bay and Belcher Road. The contract in the complaint at paragraphs 12, 13, 14, and 15 confirm that Bridgeport was to locate, research, secure, and or obtain suitable properties located at traffic intersections for commercial development of future locations of CVS. Again, what is clear is what the contract was meant to be, and the court can construe for statute of frauds purposes the intent of the parties and the length of time of the contract. I want to focus on the statute of limitations because the statute of limitations specifically bars all three of plaintiff's claims. Number one, the breach of contract. Number two, the unjust enrichment. And number three, the fraud claim. The unjust enrichment case is barred because the services were last performed 4 years from the date, or the services were last performed many more than 4 years prior to the filing of the contract, the complaint at issue. Opposing counsel has said it's not clear from the record when the last services were performed, but what is clear is that this case was filed in 2006. There were no services performed in 2006. There was no services performed in 2005. There was no services performed in 2004. There was no services performed in 2003, none in 2002, and none in 2001. And then we have the December 1999 and January 2000 letter, which specifically informed the plaintiff that there is no exclusive agreement, that he is not an exclusive broker, that he will not be paid $100,000 for real estate commissions, and importantly, the January 2000 letter tells him, here is a list of properties that you may be paid for if these deals close. The plaintiff admits in its brief, this property was not listed on that paper. There is no question that as of January 2000, Bridgeport knew or should have known that CVS breached this alleged oral agreement, even assuming all of the facts in the light most favorable to Bridgeport, that this agreement existed. Bridgeport knew that the misrepresentations that it would be the exclusive broker, that it would be entitled to $100,000 of commission, that it would be paid a commission for this property, were all false as of January 2000 when it received that specific letter. The breach of contract, again, is 4 years from the date of breach, even though damages might not be realized until later. Bridgeport cannot argue it's because of the commission. It was at the date of the commission that the breach occurred, because it was told in January of 2000, assuming the agreement is exactly what they say it was, that we don't think there's an agreement, we're not paying you under an agreement, and here's properties that do not include the one they've sued upon and is on appeal before this court, and you are not getting paid in this. Bridgeport can't put its head in the sand and later say, well, we thought maybe we'd be getting the commission, when that letter specifically says you're not getting it. There was an anticipatory repudiation of the contract right then and there, and their cause of action accrued at the latest January 2000. Also, the cause of action for fraud. When plaintiffs knew or should have known about the misrepresentations, again, the Second District and the Florida Supreme Court have both confirmed that it is on the date that they should have known about the misrepresentations, not when the commissions weren't realized. There's a couple cases that are directly on point that deal with commission cases. The Merle Woods versus Trinity Yacht case, the medical jet case. They talk about the fact that even when nominal damages accrue, that's when the contract's breached, that's when the fraud is realized. So those causes of action accrued more than 6 years prior to filing of the complaint at issue, and they are therefore barred by the statute of limitations. The statute of frauds also bars the contract because it's designed to prevent persons from being enmeshed and harassed by claimed oral promises made in the course of negotiations not ending in contracts reduced to writing. It's important to see from the complaint what is pled by the plaintiff, what is the object to be accomplished. And that is a decision that is under this court's jurisdiction. The court can decide what is intended by the parties of the contract. What is the contract as a whole that's being sued upon? And again, it was to locate, secure properties for CVS so they would penetrate the Florida market. Again, it is not a reasonable, it is not a genuine issue that this contract could have been performed in 1 year. Britt Goodson admits that it was 30 to 40 properties in both counties that the two of them were supposed to secure. To even argue that 30 to 40 CVS stores could have been negotiated or contracted for, or the services provided for a broker, is clearly not a genuine issue. That is a made up, that is a false, that is not a colorable issue, and therefore the statute of frauds applies. The Linksys Communications case from this court from 2007 indicates that when no time is agreed on for the complete performance of the contract, and we will agree that there's a genuine issue as to what the time is, but if from the object to be accomplished by it in the surrounding circumstances, it clearly appears that the parties intended that it should extend for a period of longer than a year, it is within the statute of frauds. Carolina Holdings, the original developer in this case, said this was going to be for numerous years. It was CVS coming into Florida back in 1999. There is no way it could have been in 1 year. And also, where it's possible that the one closing at issue could have happened in 1 year, that does not mean it escapes the statute of frauds. Specifically, the third district case of Tobin versus Zeskin is right on point. You can't look at the contract in a vacuum. You have to look at the object to be accomplished. It was these brokers helping CVS to come into the market. It was to be over 1 year. Also, the fraud claim is barred by the statute of frauds as well. Now, the plaintiff has contended that it's suing for a fraud and deceit, but the action under the circumstances here is simply an attempt in an indirect manner to obtain damages for breach of the contract. The case of IT Cohen versus Pullman, which we've cited to the court, it's a Georgia case, but it refers to a Florida Supreme Court case of Cannell versus Arcola, which this court recently discussed and relied upon, in which they found that fraud cases are sometimes disguised as breach of contract cases, and that's what this is. It is clear because of the prayers for relief in the complaint. It's clear because of the interrogatory responses, which show that the damages being sought by plaintiff for both the fraud and the breach of contract case are duplicative. Therefore, a fraud claim cannot also survive the statute of frauds. Plaintiff has argued that there's a question of whether full performance had occurred, and therefore does that take it out of the statute of frauds. Again, looking directly to what the plaintiff has pled the contract to, and assuming the facts in the light most favorable to the plaintiff, there is no question that full performance hadn't occurred. The complaint specifically says they were to secure suitable properties for commercial development, and we have cited, and I love the use of Black's Law Dictionary in our briefs, the definition of what a broker is. Plaintiff is a broker, a real estate broker, and a real estate broker is specifically a person who procure the purchase or sale of land, acting as intermediary between vendor and purchaser, and who negotiate loans on real estate security, manage and lease estates, a broker employed in negotiating the sale, purchase, lease, or exchange of lands on a commission contingent on success. This court, in construing contracts, written contracts, and in this case an oral agreement, must use a reasonable interpretation, not a strained interpretation put forth by the plaintiff. Therefore, based on the plaintiff being a broker, the plaintiff's admitted facts in its complaint, and also its interrogatory responses, which are in the supplemental record, it shows that there is no question of fact that they did not fully perform under the alleged oral agreement. The fraud claim, I'll mention, is not only barred because of the statute of limitations and the statute of frauds, but it's barred because there is nothing in the record to show that the statements at the time they were made were false. The second prong is that the maker's knowledge that the representation is false at the time it was made. The statements that the plaintiff is suing on are specifically that you are going to be our exclusive broker. Again, they completely overlap the breach of contract case, but for purposes of whether they have pled the four prongs or whether the evidence before this court shows that those four prongs have been shown by the plaintiff, clearly they haven't. Joe Kasich allegedly made a statement, you're going to fully perform. What happened is a new developer came in, chose to use a different person, and Bridgeport was specifically told, we are not using you. There is no evidence at all in the record that the statement by Joe Kasich, at the time Joe Kasich made it, was in any way false, and that's a necessary prerequisite to having a fraud claim. The procuring cause issue, although it is a difficult question and typically one for the jury, there has to be something to bring the parties together to brief procuring cause. Of course, based on the statute of limitations, all of the claims fail. They've not even pled this really as a procuring clause claim, but based on the evidence before the court, the buyer and the seller were not brought together and a sale was not effected as a result of continuous negotiations inaugurated by the broker. Specifically, we have been presented with a couple contracts to the two sellers. Importantly, if you look at them, the contracts weren't from the plaintiff. The contracts were from another party, Britt Goodson, and they identify Britt Goodson as the broker, and importantly, they have an expiration date, July 1999. Britt Goodson isn't suing. Those contracts are not admissible evidence in this case of whether the plaintiff, Bridgeport South, was the procuring cause of the transaction. So the only thing before the court to indicate that Bridgeport South was the procuring cause of this particular transaction, and if you notice from the briefs, there's an argument, and Bridgeport is attempting to expand the law, that if Bridgeport introduces the buyer to an adjacent property, it somehow is the procuring cause of the property that closed. That's simply not a law. There's no cases cited that stand for that proposition, and plaintiff can't expand the law to encompass that. So you have to look at who the sellers were in this particular case. They were two, Pauline Rofi and Motiva Enterprises. There is one letter that was presented as an attachment to the reply brief, the amended reply brief, that is a letter from Bridgeport to Pauline Brophy that, interestingly, is dated the same day that Bridgeport got its cease and desist letter, and also a month after the record reflects Bridgeport was told, you are not going to be the exclusive broker. There was a meeting. They knew it wasn't going to happen. And I'm not sure, but the date of the letter before the court on the pages after that is, in fact, 5 days prior to the date of the cease and desist. Nevertheless, that is not enough. There's no sales negotiations, there's no price, and there is no evidence whatsoever in the record that Bridgeport had any contact with Motiva relating to this particular transaction at issue. Therefore, they can't be the procuring cause, although that's only an argument that is gotten to after, because the statute of limitations issue bars the claims, statute of fraud issues bars the claims as well. And the cases cited by the plaintiff do not change that analysis. So the lower court was correct in ruling as a matter of law that the facts before the court, especially the December 1999 letter and the January 2000 letter, in which Bridgeport was specifically told, and I'll reference just a couple excerpts of the letter, Kathy and Joe deny that they ever made any representation to you that could reasonably be construed as creating or implying the existence of an exclusive brokerage relationship. Even arguably, if created, it was terminated as of your meeting with Peter Corbett when he told you that you would not be working any longer. Specifically, here's a schedule of properties for which CVS and Metro are willing to cooperate, and any commissions would be limited to $25,000 versus the $100,000 that is claimed to be a part of the agreement. The breach and the fraud were apparent right then and there as of January 2000, and the appellant / plaintiff has admitted in the record that the Belcher and East Bay site, and it's apparent from the letter January 20th, 2000, that it is not on that site. For these reasons, we would ask that this court uphold the lower court's ruling granting summary judgment in CVS's favor. Thank you.
Thank you.
If it pleases the court. First of all, she argued statute of limitations for fraud and breach of contract. That was not argued to the trial court. It was not briefed and argued to this court. It is not before this court. Even if the statute of limitations for fraud and breach of contract were before this court, which it is not, it still would not carry the day, because in this case, the breach of contract, for instance, includes the procuring cause of action. They are the ones that put that into it, that this oral contract requires procuring cause. Procuring cause, as we all know, does not accrue until there's a closing. There's just no way to have a procuring cause of action, which now is included, it's embedded into this breach of contract. But as I said, these are not even before the court, the statute of limitations on fraud or on a breach of contract. They argued on the breach of contract we were not procuring cause, and they argued on fraud that we failed to state a cause of action. They did not argue statute of limitations until oral argument at this minute. There are genuine issues of material fact as to those two letters she mentioned, as to the intent of those two letters. We have plenty of evidence about that, and we don't need to get into that because, again, statute of limitations is not before this court right now. She talked about fraud and the intent. Again, they're arguing inducement. We're arguing continual. And I would also like to bring out that in Florida, reckless misrepresentation is good enough for fraud. That is good enough for the intent and the knowledge. We have testimony from Kathy Evans, who was CVS's real estate director, that Joe Kasich didn't care. He was very careless about that. He wanted to get things done. He was reckless. He would tell you whatever he wanted to tell you and would do whatever he wanted to do to get it done and didn't really care about the consequences. That's what we have here. We have at the very least reckless misrepresentation, but I think regarding the written contracts, I don't think that was reckless. I think he was purposely telling them. I think the evidence shows he was telling them, yes, you're going to get your written contracts, and he was telling the CVS attorneys the exact opposite. That is fraud. she mentioned Peter Corbett way back in November. The testimony regarding Peter Corbett, who was one of the developers, was the opposite of what she said. They brought in Richard Liberto, that's another part of the fraud. Clay Wilson brought in his buddy and to intentionally exclude Bridgeport. And at that time, of course, there was concern. Peter Corbett told Felix Fudge, don't worry, keep working. He's going to a completely different market. You keep working, especially on the sites that have been improved. And this was one of the sites that had been approved, that he had contact with the sellers. It's the exact opposite of what I believe she just represented. Even if it's not, those are genuine issues of material fact for a jury. Contrary to what she just said, the evidence shows that Felix Fudge had conversations with Motiva regarding this specific site. There is a deposition testimony that says, and what specific conversations did you have with anyone from Motiva relating to the East Bay and Belcher Road location? Tim Lowe was the real estate guy, so that's the only person I talked to. Question, did you talk to him specifically regarding the East Bay and Belcher Road location? Answer, I did. Question, what did you talk to him about? Answer, the sale. Question, did you tell him that you may have a buyer that was interested in that location? Answer, I did. And what was his response? And it goes on and on. So the evidence shows he contacted. Also, as she misrepresented, the letter to Pauline Rofi is dated 12/13/99, a day before the 12/14/99 letter, and we don't know when Felix received the 12/14/99 letter, but the Paula Rofi letter is 12/13. And in that letter, he represents that there were earlier conversations with Pauline Rofi. It says, per our conversation, I'm sending you this letter to reiterate that I have a buyer that's interested in your property. Lastly, for instance, Lincus is not dispositive of this or any of the cases they cite, because, for instance, in Lincus, it said it was a stillborn business arrangement or business opportunity. We have performance in this case. We have at least have partial performance in this case, and that brings it outside the statute of frauds. We are way past negotiations. There was substantial performance. I would ask that the court would please reverse this case and send it back for a jury trial where it belongs for all these issues of fact. Thank you.
Thank you, Ms. Townsend. Thank you. Next case is Yanni Smith versus Philip Smith.